Okay, good morning, all of you. Am I audible? Yes. Okay. Okay. So yeah, I have shared the link on the group. So rest of them, let them join and we shall start the class. So yesterday we were doing the first chapter, types of economic, political, and legal systems. So today I will be continuing with that. So first I'll go to the revision, whatever we have done, the quick revision. And one thing I want is that you all to please participate in the class. So then only I'll be able to know that whether you are getting the topic or not, right? So a good morning, a very good morning. I need a good morning from all of you. Just unmute yourself and say, because in the chat I'll not be able to see. So you have to unmute and tell me.
Good morning, ma'am.
Yeah. Only one good morning I've got.
Good morning, ma'am.
Morning.
Good morning, ma'am.
Good morning.
Good morning, ma'am.
Morning. Okay. So I'll just start the class. So all the rest of them who are going to join, they can continue in between the class. Okay. So I'm just sharing my screen right now. So if anyone could tell me, like, what did you understood by the term common law, civil law? Anyone would like to tell? Okay, I'll just share my screen. I'll just write and for your reference, okay? So, common law, what do we mean by that? keyboard is giving a bit trouble. The A is not typing, so it's slow, okay? So it basically refers to a body of law that is developed through judicial decisions as opposed to laws created by legislative statutes or executive. Okay. Or executive actions. So yeah, sorry, my keyboard is giving a bit of trouble. I just explain it to you in the normal terms. I wanted to write it down so that is more clear to you, but hopefully while explaining, I'll make it clear while speaking. Basically, what was common law? It was a body of law that was developed through the judicial decisions, as opposed to the law that was created through the statutes, legal statutes, or the executive actions, right? So it was basically based on the precedents, and meaning it was basically relying on the principles that was being established on the basis of the previous court rulings to resolve the similar legal disputes, right? So common law was this. And civil law, what was civil law? Civil law basically was a legal system. It's a legal system which is primarily based on the written codes or statutes, as opposed to the case law that is developed through the judicial decisions, right? And if I'm saying what was statutes, so statutes was the written law that was created by the, or you can say enacted by the legislative body, whether it is a parliament or a congress. So these were the basic terms which we had done yesterday. Now let's continue with the rest of the chapter which was being left. So now comes the rules of statutory interpretation. So the courts have also developed the number of rules for statutory interpretation. So these rules, they help the judge to apply the words of the statute if they are unclear. Okay. So first is the literal rule. So words should be given there. What does literal rule means? It should be given the plain, the basic, the ordinary, literal meaning. So normally a word should be interpreted in the same literal sense wherever it appears through the statute. Simple literal meaning should be taken in whenever the literal rule has been applied. Okay. Now comes the purposive rule. So under this approach to statutory interpretation, the words of a statute are interpreted not only in the ordinary, literally, and grammatical sense, but also with the reference to the contents and purpose of the legislation. What was happening in literal rule? They were up. You need to follow the same literal meaning wherever it is there. But in the purposive rule, you have to make reference to the context and the purpose for which the legislation is there. That is what is the legislation trying to achieve. So this shows that how the court took account of the mischief or the legal wrong which the statutes was explicitly intended to remedy. Okay. Then comes the contextual rule. So a word should be interpreted in its context. That is, whatever the context is there. It is permissible to look at the statute as a whole to discover the meaning of a word in it. Then comes the elustem generis rule. See, these are the terms which are there. You don't have to learn that. Simply, you need to identify what is being given, the definition, what is being there. You don't have to learn these things, okay? So in this, if you're seeing that elustem generis rule, a statute often lists a number of specific things and end the list with more general words. In that case, the general words are to be limited in their meaning to other things of the same kind as the specific item which precede them. So, and in expressio ulis est exclusio altris rule. So, to express one thing is that is by the implication to exclude anything else. So, for example, if you're going to say a statutory rule on sheep does not include goats, okay, so you have to be very expressive into one thing. Then comes the Knoxler Sol's rule. So a word draws meaning from the other words around it. So basically, if a statute mentions the children books or children toys and clothes, so it would be reasonable to assume that clothes meant children clothes. It should not be assumption based on the other words. Okay. Then comes in pal matrilineal rule. So if the statutes form part of a series which deals with the similar subject matter, so the court may look at the interpretation of the previous statutes. Like in common law, what was happening? We were looking at the previous judicial rulings. So on the assumption that that parliament intended the same thing. Okay. So these are the basic rule among the three, the literal, purposive, and contextual rule. You have to memorize these. Like what does it basically means? Then comes the judicial review. So that we noted previously that a US citizen has the right to challenge law which appears to be unconstitutional. So US citizen has that authority. So the role of determining whether created law they conflicts with the constitution, they falls to judges. Like they will determine whether the conflict which is there, whether the you can say whether the conflict of the law is there or not, it lies on the judges. Okay, so in the courts, notably the US Supreme Court. So there are two major theories in the US as to how judges should do that, whether the particular, whatever you can say, the US citizen is challenging the law. So whether it is right or wrong, it basically, so US judges has to do that with, like you can say, they have two major theories, that is originalism and constructivism. So this is important, okay? Originalism and constructivism. So what does originalism means? So the theory that the constitution should be interpreted according to the original intent of its authors. So it should be interpreted according to the original content. There should be no no presumption or assumption should be made. Then constructivism, like the theory that the constitution should be interpreted looking beyond the original intent of its author. So there could be drawn various assumptions in the constructivism theory, okay? But in originalism, you have to abide by the original intent of the author. So this is the major difference among the two. So the risk in any interpretation, like is particular, but particular in constructivism, goes beyond the intent of the authors. So is that in effect, nothing acts as a check to the court except its own good judgment. So what do you think would, where in which among the two there will be more risk, in originalism or constructivism in terms of judgment? Any answer? Yes, it's constructivism, right? Okay. Then comes the civil law system. So civil law was basically developed in the continental Europe. So during a period of revolutionary change and the state forming, so the following section, they uses the French legal system to illustrate the main features of the civil law system. Okay, so could you please tell me now how many of you have the book with you all? Just mention it in the chat that you have in the book or not. Okay. Okay. Hmm. Okay. So most of you are having right now. Good. Then civil law. So basically, a key period in the development of the civil law was the era of revolution in the Western Europe. So here, a basic history and the background of it is given. So in the late 18th and the early 19th century, so it was after these revolutions that the emerging nations decided to codify their law, abolishing the mixture of the common law and customs remaining from Roman times and establish a national law. So what are the basic key principles of the civil law system? Now this is important, okay? The two main key principles are the comprehensibility and the certainty. So this can be seen in the codes that provide the hallmark of civil law and the different role that is being allocated to judges in the civil law system compared with the common law system. So here, what do we mean by the codification is being given? So codification is basically, you can say the laws are systematically codified into comprehensive legal codes. You can say the civil code or the penal code or the commercial code. Okay. So what happens is, so these codes, they provide the primary sources of law. That is detailing the legal principles and the rules. So in codification in France, the process of lawmaking can be seen in the period that is after the French Revolution in the years following 1789. So see, these are the basic background that is being provided in the book. Okay, this will not come in your questions like it was in which year it was being formed or after what happened, and all these will not come, but you should be aware of the terms that are there. Okay, so for example, I told you like over here in the judicial review, like what are the two major theories in US that judge uses, that is originalism or constructivism. So these are the points which are important, which will come in your MCQs, okay? So, but over here, whatever is being given, just for your knowledge, you should be knowing, because since you are doing the international law, so you should be aware of that, okay? So the French Civil Code, the Code Napoleon published in 1804 is the key example. France now has a large number of such codes of law. So the German Civil Code was published in 1896. So where law is codified in civil law system, it is generally codified so as to provide a comprehensive code of the enacted law in a certain area. Fine. So code of law are a common feature of a civil law. So why code of law are a common feature of civil law? Why do you think? What is a civil law? I have explained it to you in the like revision part also. Now, if I'm going to ask you what is civil law, so can you please write, if you're comfortable in writing, then can you please write in the chat, what do you understand by the term civil law? Then I'll make you relate with the code of law, how it is being related. Display could be more visible, but yeah, it is not, uh, uh, the size of the fonts are not increasing, though I am used different techniques, but it is not happening. Since I'm using the bookshelf app, that is why I'm not having the PDF of the book. Otherwise, this issue would not have been there. Okay, but I will try talking to the editing if anything could be possible from the next class. So the rules which protects the rights of common people in a country. Okay. Any other answer? Anyone? That is fine. That is fine. But any other legal answer which could be provided? Try. Just try. I just need the answer. I just want to know whether you are understanding or not. Just write and tell me. No issues if you don't want to speak. So civil law is something which was basically based on the written codes and the statutes, right? And what was common law? It was based on the previous judicial rulings. That was the difference, right? So what was happening? Code of law, since codification, what we studied, that it was basically the laws that are systematically being codified into comprehensive legal codes, right? So don't you think code of law are a common feature of civil law? Since they are not a compulsory feature, but it is a common feature. Clear? Okay. Now comes the sources of law. So there are various sources of law in France. First is the Constitution, European Union law, statutes, administrative regulations, customs of that is of limited importance. So we shall not be considering this further. It is being written in the book. So the key sources of law is the statute, much of which is codified, and administrative regulations, these are also codified. Okay. So if I'm going to say statute, yesterday also I've explained you what is statute. So what is statutes? Anyone? Any answer? Yes, it is a written law that is enacted by, or you can say, that is being acted by the legislative body. Okay, whether it is a parliament or whether it is a congress. Yes, it is a written law. Codified means it is a written. So here, what is being written? The key source of law is statute, much of which is codified. So administrative regulations are also codified. Don't you think it should be codified? Statute law is usually drafted as general principles and in simple language as far as possible so as to ensure that law is accessible. Now comes the role of the judges. So the role of judges in a civil law system is significantly different in theory from the role of a common law judge. So how do you think it is a difference? The role of judge in terms of civil law, in terms of common law, how their role will be different? Why do you think so? And do you think so their role will be different? First question. And why different is my second question. Who will answer me this question? Anyone? You should be attempting, see. Once you're more participative, your thinking will expand. It will help you, I'm telling you, as a
Can
student.
I try once? Like, I don't know if I'm right or wrong, but I'll
Yes?
try.
Yeah,
Yes.
you should try. That's what I want from you.
Yeah, so the role will be different. Like,
Yeah, yeah.
from in civil law and in common law, the
Mhm.
role of judges will be different because civil law deals with some like both civil law and common law are different and they are dealing with different parts of the law. So the roles will be different.
Yes, since common law, the judges are more looking into the judicial rulings part while giving their judgment, and in civil law, they have to follow the written codes, right? The statutes. Okay, that's the difference. Why they are different is the main reason. Clear? Since you tried, you attempted, that is the good part. Now comes in France, there is a distinct division between those who draft the law and those who apply the law. So judges being the latter means judges are not involved in drafting the law. They are only applying the law. Okay? Where is this happening? In France. So there is no such thing in France as judge-made law. So while previous decisions of other judges will be persuasive to other judges while making decisions, so they do not create precedent in the same way as in the common law system. So France has the code of cassation. What? The France has the code of cassation. Now this is important, okay? This is an appeal court where court decisions can be quashed if legislation has not been interpreted correctly. Fine. Now comes the statutory. Yes, judges do play. Yes, you were right. That they play an important role in common law and doesn't follow the civil law. Right. You've understood it well. Good. So in statutory interpretation, there is no general principle in French law on how judges should interpret statutes. So this is probably due to the historic feeling that judges should not interpret the law but merely apply it to the letter. So however, general principles of the statutory interpretation have been developed. So what is that? You have to see over here, the interpretation part, okay? You don't have to see the left-hand side part, whatever it is being given in French. So where the meaning of the law is clear, it must be followed. So French judges will not extend or restrict the scope of a statute that is unambiguous. Okay. Then comes a where the statute is obscure or ambiguous, that is not clear. One should construe it in accordance with the spirit of it rather than to the letter in order to determine its legal meaning. Means that when the law is clear, like when the meaning of the law is clear and it must be followed. So like it, and when the law, the meaning of the law, whether the statute is not clear, that is obscure or ambiguous. So one should construe, one should take it or understand it in accordance with the spirit of it, whatever it is being given, okay? So rather than to the letter in order to determine its legal meaning. Now comes if there is a gap in the law, that is judges must resort to the custom and the equity. However, despite this, custom is only of limited application in France. So if I'm going to say about equity, yesterday I have done this term equity. What did you understand by the term equity? Since custom is not applicable to our syllabus, it has not been explained, but equity has been explained. And I told you all yesterday what does equity means. What were the, you can say, the drawbacks of common law? Because of it, equity was introduced, right? So what was the reason? I just gave you the hint. Try. You can do it. Anyone willing to answer? It can be changed or updated. No, better answer, better answer. It was basically a body of law that was being developed to supplement the rigid rules of the common law. Like it has become because focusing on the more fairer and justice. Yes, it was applying on to improve it, to make it more flexible, since common law is what? Inflexible, right? To make it more flexible. So since focusing on more fairness and justice in situation where the application of the strict legal rules would have led to the unjust, you can say, or that is, or you can unjust outcomes, okay?
Sorry to interrupt, ma'am.
Yeah, yeah,
So just
yeah.
a small that. Like we no need to focus on these French words. Just we need to look into that English word. I just have a doubt. Like
I'm sorry to interrupt you right now because your voice is not audible. There's a lot of distortion when you speak, actually. So I don't get what you're speaking. So if
I'm so sorry. I think I have some network issues.
yeah. So just speak a word like a single word, maybe then.
Now,
Yeah.
yeah, is it audible now?
It is like a bit of better, yeah.
Okay, so then I'll type it
No,
now.
it is better. Now it is better, yeah. Speak then.
Okay. So, what my doubt is like there are some French words now in the slide. So, while studying, we don't need to focus or look into that words. We just need to focus on the English words. That's it, or we just have to understand that as well.
So
Like,
your
yeah,
question is that you have to focus on this left statutory interpretation part, or you want to focus on the meaning part? You are asking this, right? This question?
yeah, like we French words we can't understand first. So, will it affect that in exams the questions will come related to this French word as well, or
No, no, no. It will not come related to your French word. That's what I told you. You have to
yeah?
understand the meaning, basically, okay? They'll not ask you this French statements and you need to interpret. This will not happen. Since I'll be doing the question
Yeah.
answers also with you after completing the chapter, then you'll have a better understanding how the questions are going to come, okay? But you don't have to learn all this.
Okay, I just had
Hmm.
yeah, I just had it out because that words are in our books. That's why I just had it out.
Yeah, it is being given for your understanding so that you better understand the law, but you don't have to learn all this, okay?
Okay.
Yeah. So now comes the alternative methods of the statutory interpretation. So there are only the few following alternative methods of the statutory interpretation. That is the theological method. This is where a judges seeks to identify the social purpose of the legislation and apply it a manner that achieves it. So now the question can come from this part, okay? That what are the alternative methods of statutory interpretation, okay? So now you should be knowing the theological method, the historical method, okay? The question will be coming on this kind, right? Now, in theological method, the judges, they seek to identify the social purpose, what is the social purpose of the legislation that is being there, and apply it a manner that achieves it. Okay, that is your theological method. Now comes the historical method. That is, this is where the judge look at the intention of the legislator. What was the intention behind introducing the certain kind of, you can say, statute or law or code. So, and then tries to envisage what the intention would be if the law was being drafted in modern times. Since, see, law, whenever the law is being framed, it was being framed according to the whatever the you can say scenario or the circumstances is there at that time. Since every time the world is changing, the scenarios are changing. So now what happens is the judge try to look what the if the law was being drafted in the modern times, what would have been included. Okay. So the judge then applies that intention. So here, what is happening? There is a difference of intention in both the methods. First is the theological and second is the historical. Then comes the judicial review. So although in the civil law tradition, judges do not have a key role interpreting the statute, a system of judicial review has grown in certain civil law countries. So the risk role is to comment on whether the statute law is in accordance with the country's constitution. So this is the case in Germany where constitutional court has been set up for this purpose. So the judges in constitutional court are not the same as in the normal court system. In other words, special judges are created to comment on whether legislation is constitutional. Now comes the Sharia law system. We have done the common law system, the civil law system. So third was the Sharia law system. If I'll take you back on that chart which is being given. So what we have done, types of economic, political, legal system we have completed. Legal system we have done, common law system, the role of judges, civil law system, the civil law. Now we are at the last part of the chapter, that is the Sharia law systems. Okay. So the major difference between the Sharia law and the other legal system is that Sharia law is explicitly based on connected with the religion of Islam. Okay. We shall describe that Sharia law in general term, but also use Pakistan and Iran as example of the countries that have adopt Sharia. So here what is happening in common law and civil law, there were proper codes, the proper systems are there, or the rulings are there that is being followed. Okay. But in Sharia law, it is basically based on the religion of the Islam. So what is Sharia law? Is a way of watering place. Sharia, what does it mean? Is a way of watering place. Is a way to a watering place. In other words, a path to be followed. Sharia law is ordained by Allah as guidance for mankind. So please note that the Muslim calendar is different from the Western systems of the year BC and AD, that is before Christ and after that. However, for the purpose of comparability with common and civil law system, the AD dates are being used here. Okay. The key principle behind the Sharia law is that it is the divine way that has been ordained by Allah for the man to human beings to follow. The law, therefore, is sourced directly from Allah, and this has been a significant impact on how it is being interpreted by the judges. In true Sharia traditions, judges are being known as the imams. So the key source of law in Sharia is the Quran. Whatever is being mentioned in the Quran, so the imams have to follow that, which contains various injunctions of the legal nature. The Quran was being revealed to the Prophet Muhammad during the last years of his life, that is around 619 to 632 AD. It was being written down piecemeal during his lifetime, but not collated until after his death. So Quran includes the various injunctions of the legal nature, but it does not cover every detail. So another primary source of law of Sharia, you can say in Sharia, is the Sunnah. Then comes the secondary sources of law. So there are basically 5 major secondary sources of law in the Muslim one, that is known as madhab. So you have to remember the major secondary sources of law, what is being known as madhab. Okay. So these are the school of thoughts that are being based on writings and thoughts of the major jurists that is being formed in the years following the immediately following the death of the Prophet and are named after those jurists. First is the Shia school. Second is the Hanfi school. Third is the Maliki school. Fourth is the Hanbali school. And fifth is the Shafi school. So you have to remember these, okay? These schools of law are given more prominence in certain parts of the world. So, for example, parts of Iraq and parts of Iran, they follow the Shia school, that are Shia Muslims. The majority of the Muslim world, they follow the other four school that are together termed as Sunni. So, in Pakistan, generally preferred school is Hanfi. Now comes the constitution. So many Muslim countries such as the Iran and Pakistan, they have a written constitution that upholds the role of Sharia law in that country. So constitution is based on the Sharia law. Role of judges, as we have observed. So religious nature of Sharia means that in true Sharia tradition, judges are the clerics known as imams, as we have seen earlier. So this is the situation in Iran, for example. However, in other Muslim states, there are mixture of clerical judges and the secular judges. So judges are required to apply the law that is being to cases that is being brought before them. However, given the nature and the source of law, there are particular consideration with regard to the interpretation of the law. Since the Quran cannot be altered, being the words of Allah, so it may only be interpreted. Okay. So this leads to the problem in Islamic circles who are qualified to interpret the Quran, since interpretation could be done in any way, right? It could be done, whatever the words that are being given in the Quran should be interpreted in a correct way. So Muhammad, as Allah's prophet, was qualified to do so. When clear guidance cannot be obtained from the Quran, the judge may turn to the Sunnah to see how the Quran was being interpreted by the prophet. So the Sunnah is being used by a Muslim jurist to confirm the law in the Quran, explains the matter which is being mentioned in the Quran in general terms, clarify verses in the Quran that may seem ambiguous, that is not clear, then introduce a rule where the Quran is silent. So the ahadith that comprise the Sunnah were recorded after the death of the Prophet and are being classified according to reliability. Some are virtually guaranteed and are known as muwatir. Others are less certain and known as mashtur. So this is important, okay? This could be asked. Lastly, where there is less certainty or as to their authenticity, ahadith are called ahad. So there is controversy in the Muslim world as to whether matters of the legal and religious significance should be interpreted further or whether everything is clear and new cases should not be bring the need for further development of the law. Now comes the taqleed. So the theory that no more interpretation is needed is known as taqleed, okay? Which is the process of strict adherence to the established doctrine. Whatever has been established, you have to abide by that, okay? There should be no more interpretation. So what does this word mean? Word will mean taqleed, okay? Orthodox Muslim would adhere to the taqleed, although some would claim that there was a need to deal pragmatically with the results of new Western influence in their countries. Now comes Ishtihad. So those that believe more development is being needed have developed the science of understanding and interpreting legal rule, which is known as fiqh, through the techniques of Iqtidar. So where there is no interpretation, that is known as taqleed, where there believed to be more development is needed or have a science of understanding or interpreting the legal rule, that is known as fiqh, okay? Through the techniques of Ijtihad. The basis of for Ijtihad is a hadith that which records that the Prophet approved on an imam who told him that in making a judgment, he would rely first on the Quran, then on the Sunnah, and then he would exert his own judgment. Okay. So there are various rules that is being associated with exercising on ijtihad. It must be exercised on certain matters. The judge must be suitably qualified, that is muhtahid. And third is there are various recognized methods. Now let's see as muhtahid. So in order to qualify as a muhtahid, a person must be well versed in the study of the Quran, well versed in the tradition of the Prophet, understand the principle of ijma, understand the conditions for qiyas, a good and practicing Muslim, and just, reliable, and trustworthy. So one reason there is controversy about whether interpretation shall still take place is that many people believe that the qualification criteria are too difficult in the modern times, given the time lapse since the death of the Prophet. So the two of the recognized method for exercising ijtihad have been mentioned in these qualification criteria. So the full list is being given over here, okay? First is ijma method. So it's a consensus of opinion. It should be based on the consultation between the jurist. Now comes the qiyas. It is analogical deduction. In other words, it is a comparison of two things with a view to evaluating one in the light of the other. Then comes the istihsan, that is concept of equity or fairness. Then maslahasal mursala means something very similar to istihsan, that is concept of equity or fairness. Urf, the theory that local custom may be subsumed in the law if it is not contrary to Sharia. Then istihsab, a legal presumption that the current state of affairs continues until the contrary is being proved. Now comes the judicial review part. So in some Muslim states, the state will issue statutes, although these should be based on the Sharia law principles. In addition, since wholesale adoption of Sharia by Islamic nation is a fairly recent trend, there may be enacted law before the adoption. Now comes the rule against the usury. A rule in Sharia law states that a rule in a Sharia law that has a significant impact on the commerce and trade is the rule against the usury, known in Sharia as riba, that is interest. Since the Islamic concept of unlawful gain, so Muslims are not allowed to keep the interest or use the interest, which is strictly prohibited by the Quran. You are not allowed to even pay or receive interest in any form. So in theory, riba, unlawful gain, translates to be qualitative inequality and is a highly technical area. For our purpose and in practice, it is often seen as a rule against the charging or receiving interest. So the concept of riba has a significant impact on the way that Muslim banks, which you should be aware, although we shall not look at details of the Muslim banking in the course book. Okay. So here is the chapter summary. Just have a look at it. Please let me know once you have done, like have a proper go through it. If you have any question, you can ask me. Otherwise, I'll proceed further. Done? You with it? So shall we proceed to the question answer round? Okay, now I'll be wanting answer from you all. Okay, you can mention it on the chat. Okay, but you have to answer. Fine. All of you have to answer. I'll not ask you to unmute yourself or answer. You can mention it on the chat. I'll just see the answer. Okay. So the first question is, in which of the following types of economic system does the government make all the decisions regarding resource allocation? That's a very simple one. Answers? Okay. Only one has answer I've received. Where are the rest of the answers? More answers. Okay. Not everyone is participating. You have to participate. Just try. It's not important that you're giving wrong answers, so I'll make a judgment. That's not like that. At least I'll be very happy. At least you're taking initiative to answer. Obviously, you're not giving the right answer since you have not gone through it. You've just seen the class. At least you should try. That is my main motive, that you're trying. I'll see your efforts that you're trying. That matters to me the most. Okay, good. Come on, more answers. I've got only 4 till now. Good. Okay. Now I'll give you the answer. Since most of you have said the planned economy, so I'll just see whether it is right or wrong, okay? When I'm submitting, it is the right answer. Planned economy, so in this, the government makes all the decisions in the planned economy. In a market economy, market forces, they determine the resource allocation. A mixed economy involves some government decisions and some market forces in resource allocation. Now comes the second question. Which of the following statements concerning positive law is correct? First is, it is being created by the international legal organizations. It is the law that a state imposes on its citizens. Law that is being created by democracies but not dictatorships. What do you think would be the answer? Right, right. Okay, okay, good, good. More answers? Okay, since most of you are saying the option B, that is positive law is the law that a state imposes on its citizen. So let's see whether it is right or wrong. So the correct answer is the positive law is the law that state imposes on its citizen. Okay, this is the correct answer. Now comes, which of the following statements describes the cause of conflict of laws? First is inconsistencies between a nation's criminal and civil law. Then comes the second, disagreement that is being caused by the differences between one nation's law and another nation's law. Third is differences in the operation of a common law legal system and a civil law legal system. So Which statement is describing the cause of conflict of laws? Now, please give your answer. Yes, good. Correct. But I need more answers. Just go through it question once. Think what could be the answer and just write it down. Okay. Okay, the answer for this, since most of you have said the second one, that is disagreement caused by differences between one nation's law and another nation's law. So let's see. This is the correct answer. Okay. The cause of conflict of law is the disagreement that is being caused by the differences between the one nation law and the another nation law. Clear? Now comes in the English legal system, what is the standard of proof in a criminal law case? Standard of proof in a criminal law case. First is the balance of probability. Second is beyond reasonable doubt. And third is the reasonable guilt. Sorry. So what is the standard of proof? This thing can answer. Okay. Okay. Right. Okay. Since majority says the second, that is beyond reasonable doubt. So let's see. That is the standard of proof in the criminal law case is beyond reasonable doubt. That is the correct answer. So the standard of proof in a civil law case is on the balance of probabilities. In the criminal law, it is beyond reasonable doubt. If a standard of proof, if the same question comes in terms of civil law, then it comes a balance of probabilities. Clear? Now, are you getting how the question will come? Now comes the fifth question, that is, in the English legal system, what is the standard of proof in a civil law case? Now the answers we have seen then. So, okay, the majority says the balance of probabilities. Let's see. Correct. As we've seen it in the early answer. Okay. When criminal law comes, beyond reasonable doubt. When the civil law comes, what is the standard of proof? That will be your balance of probability. So in the English common law system, which of the following name is being given to the rule of statutory interpretation that state that what in a statute should be given their plain ordinary meaning? It should not be interpreted in any other way. It should be given their plain ordinary meaning. First is the contextual rule, literal rule, or purposive rule. So what do you think will be the answer? Okay, fine. Okay. Just I'll just guide you in one term. Whatever is being given, since see, English all of us know. So plain and ordinary, it goes with which word? Think like that way also. If you cannot recall the concept, you can use this technique that plain and ordinary will relate among the three words that is being given. It will relate to which word? Now think. Right. Now you're right. Okay. Most of you says the second option, that is literal rule. Let's see. It is correct. Literal rule states that the word should be given their plain, ordinary meaning. In the purposive rule, judges should consider the purpose of the statute. And in the contextual rule, states that words in a statute should be interpreted in their context. Okay, fine. Then comes the seventh question, that is, which of the following describe the role of a judges in a civil law legal system? This we have done recently. So just give me the answer, you must be knowing. Right, right. All of you know. Great. That is first to apply the law only, right? Then comes your eighth question, that is, which of the following is the key source of Sharia law? What is the key source of Sharia law? On which it is being based, right? Right? Everyone is giving the right answer. That's amazing. Like since I think so past 3-4 question, everyone is giving the right answer. Okay, that is Quran, right? So key source of Sharia law is the Quran. Madhab are secondary sources of law based on the writing and thoughts of the major jurists in the early years of the region. So first is the Quran and secondary source is the Madhab, okay? Ijtihads are the processes for ascertaining the law, and Imam is a judge or cleric. So these 4 terms are important, okay? So what is the name given in Sharia law to the concept of unlawful gain, which is usually translated as meaning interest? Right now, we have done this, the interest part. Which was the word? Can you recall that word? Ijma, Qiyas, Riba or Sunnah? Right, right. Just think and answer. Everyone is giving different answer for this question. Okay, I'll go with the answer. Anyone else wants to try? I'll just give you a minute. Just try if anyone else want to. No. Okay, the right answer is riba. Okay. Riba is the concept of the unlawful gain. That is, ijma is a consensus of opinion. Qiyas is the analogical deduction, and sunnah is the source of Sharia law. So these are the 4 basic terms, the meaning of which. So this is the way you have to remember that whatever the concept is being given in terms of all the concepts. You don't have to go in every detail, but the question will be coming like this. Okay. Now comes the 10th question. Which two of the following are the mechanism in the legal system for regulating and enforcing the law that a country has put in place? First is the legislature, executive, head of state, judiciary. Now you have to focus on the word regulating and enforcing the law that the country has put in place. Now, who will regulate and enforce the law among the 4? Okay. More answers? Okay. Judiciary is there. Everyone is giving the right answer. That I will take, okay, right now. The other one, few are giving right and few are giving wrong. So that will be a last person, whoever says, then I'll jump to the answer. Right. She has given the right answer. Legislature. Okay. So legislature and judiciary, they are responsible for regulating and enforcing the laws. Okay. Now comes the separation of powers involves a state having different people acting as a head of state and a head of the executive. So in the UK, what is the name being given to the head of the executive? Monarch, President, Prime Minister, Chancellor of the Exchequer. Okay, right answer. Okay. Yeah, majorly all of you have given the right answer. That is the Prime Minister, okay? In the UK, head of the state is the monarch and head of the executive is the Prime Minister. Then what is the name being given to the party in a criminal law case who is on trial for committing a crime? First is the accused, the defendant, the claimant, or the prosecution. Who is on trial for committing a crime? Right, right. All of you are giving right answer. More answers, but more answers. Okay. It will be the accused. That is, in a criminal trial, it is the accused that is being brought to the court by the prosecution. In a civil law case, it is the claimant who sues the defendant. Okay. In criminal, it is the accused. And in the civil law case, it is the claimant who sues the defendant. Okay. Now, if I'm going to ask you about the claimant and defendant, yesterday I told you, anyone who remembers this concept of the claimant and the defendant, who will tell me? Just recall. Okay, one thing. Accused is related to which word? Claimant or defendant? Just answer me this. Right. It's the claimant, okay? It is the defendant, sorry. Defendant. Here, defendant, accused is the defendant who is being say, sued in a legal proceeding. The defendant. By the word defendant, which means you're defending yourself. You are the accused. Clear? In this way, you can memorize it. Clear? Now let's come at the 13th question. That is, which two of the following would be seen in a civil system of law as opposed to a criminal system of law? That is proved to be on the balance of probabilities, proved to be beyond reasonable doubt, a claimant and a defendant, and accused and prosecution. That is very simple, I guess. Everyone would answer. Yeah, everyone is giving the right answer. It's just a repetition of the questions which we've done earlier. Why fourth? Uh, oh, recently we have done in the last question. Just think. See, these are all 2 marks question. Can you see the marking which is there on the right hand side? Anyone else wants to try apart from the ones who have given the answer? Okay. The answer first is, right now we have done claimant and defendant, okay? So majorly you have given this. And the second? Okay. Yeah, majorly most of you have answered the first, okay? So let's see. It is correct. It will be proved to be on the balance of probabilities. And second will be a claimant and a defendant. Then comes in the English common law system, which of the following is a rule that must be met before a precedent can be applied to a particular case? The decision must be based on the question of fact. Decision must not be based on the proposition of law. The material facts of each case must be the same, or decision must form part of the obiter dicta of the case. So what do you think will be the answer for this? Before a precedent is applying to a particular case, what rule must be followed? Must be met. Right? Right. Correct. More answers, but all those who have given, they have given the right answers, but I want more answers. Right. See, most of you have said the third part. So let's see. It is correct. For a precedent to be applied to a particular case, so the decision must be placed on the proposition of law, not a question of fact, and must form part of the ratio decidendi of the case, and the material facts of the cases must be the same. Now let's come at the last question of this chapter. So which of the following is the name that is being given to the statutory interpretation in a civil law system, where a judge seeks to identify the social purpose of the legislation and apply it in a manner that achieves it? First is social, legal, historical, theological method, or common method. This we have done it today itself. Here the you can say judge is not using the assumptions. He's just identifying the social purpose and applying it in a manner that achieves it. So which two method we have studied? First was historical and second was theological, right? Among the two, which one was there? Just I've given you the hint now. Right. Since most of you have said the theological method, let's see. Yes, it is the correct method. In theological method of statutory interpretation, judge seeks to identify the social purpose of the legislation and apply it in a manner that achieves it. So the historical method is where the judge look at the intention of the legislator and then tries to envisage what the intention would be if the law was being drafted in the modern times. So in this intention that the judge applies to the case before them. So till now we have done all the question that is being related to the first chapter. So are you do you have any other question after going through these questions of the chapter, that how the questions will be coming in terms of MCQs. Now you must have got the idea like how you have to proceed with the revision of the chapters, right? Yeah. Any other question anybody's having? So now I'll be taking a 10 minutes break, and after that I'll be starting the next chapter. Okay. Thank you. Thank you. Okay, now I shall be starting your second chapter. So I'm sharing my screen right now. So this chapter is international trade, legal regulations, and the conflict of laws. Okay. So here we're going to study about the international law and trade, that is the types of international law, international trade, and the international organizations that are involved in trade. That is the UN Commission on International Trade Law, International Chamber of Commerce, World Trade Organization, Organization for Economic Cooperation and Development, and International Institute for the Unification of Private Law. So let's start with the first part, that is the international law and trade. So if I'm going to ask you what is international law, so anyone could give a just simple answer like what do you understand by this term international law? Anyone, any try? Yeah, sorry. Any try? Anyone? Right. In simple layman language, you can tell me. What do you mean by the term international law? Right. So basically, the term international law, it states that the set of rules or principles and the agreements that govern the relation and interaction between the different state or the international organization. So these are the basically rules, principles, or the agreements, this international law. Then is it there? What is the purpose of international law? Basically, it serves as a legal framework for addressing the global issues, ensuring cooperation, and maintaining peace and order in the international community. So the purpose of international law is to ensure the cooperation, maintaining peace and order in the international community. And then international law is divided into two parts, that is public international law and private international law. If you're going to say about the public international law, it is basically dealing with state-to-state relations, such as the territorial disputes, human rights, and the law of war, that is the international humanitarian law. While if we talk about the private international law, it resolves the conflict of laws in cases involving the individuals or the corporations across borders, such as international trade or contracts. So international law is there, and there are two kinds of international law, that is the public international law or private international law. Now let's look at the book. Okay. So international law is the system that is regulating the interrelationship of sovereign states and the rights and duties with regard to another. What is a sovereign state? It is a country that has full control over its internal and external affairs without any interference from the external power. They have the full regulation in their internal and the external affairs. Example of such country could be France, Japan, or Brazil. So let's comes at the types of international law. So we can break international law into basically two types, that is the public international law and the private international law. In public international law, it consists of the rules and the principle which will apply in general to the conduct of sovereign states and international organization and relation between them. So what is a sovereign state? Who has full control over its internal and external affairs and without any interference from the external powers. So they are the whole sole responsible. So what is the public international law? It consists of the rules and principles which will apply in general to the conduct of sovereign states and international organizations and the relationship between them. For example, let's see, it applies to the recognition of the states or wars or the aftermath of wars, that is the events which are considered of international significance. So part of international law is therefore dealing with the matter such as the war crimes or the human right abuses. Now comes the private international law. So private international law is the part of a nation's national law that establishes rules for dealing with cases that are involving a foreign element. Therefore, it regulates cases which involves the national laws of two or more, where a different result will ensue depending on what the state the law is being applied. So our syllabus is only concerned with the situations where individuals or corporations, they interact or act on basis of the international commerce, that is the private international law. Now comes the term international trade. Economics, politics, and law all affect international trade. Don't you agree with this? The last chapter which we have done was related to the economic, political, and legal system. Don't you think that it will impact the international trade? What are your viewpoints on this? It will. How it will impact? If there is a political turmoil, for example, if the economy is not good of a country, obviously it will impact the international trade, right? So given the differences between the economic and political systems in nations, there are therefore significant barriers to the free international trade. In practice, many barriers to free trade exist because government try to protect home industries against the foreign competitors. Protectionism can be a practice by a government in several ways. So how do you think, if you have a certain knowledge, how will you think the government will protect against the foreign competition? Do you have any idea, like any of you? They have given the several ways further in the book, but do you know any like general knowledge how the government will protect the country against the foreign competition? Right? Correct. Or suppose if they're restricting the import, for example, what measures the government will take?
Exceed import duties.
Right? Is anyone speaking? Like your voice was not audible, sorry. Okay. So let's look at how will they protect the like how Jenny. Right, right. Correct. Right. Good. All of you are at least well aware. Okay. So now first comes a tariff or the custom duties. So tariffs or custom duties are taxes on the import goods. What do they? The government impose the anti-dumping duties for suppose if they want to restrict the import, they in the country and ensure that the home country products are being more used by the consumers. So what they do in terms of import, they impose the anti-dumping duty. So the effect of a tariff is to raise the price being paid for the imported goods by the domestic consumers while leaving the price paid to foreign producers the same or even lower. So the difference is being transferred to the government sector. Then comes the import quotas. Import quotas are the restrictions on the quantity of a product that is allowed to be imported into the country. That is, the quota has a similar effect on consumer welfare to that of the import tariffs, but the overall effects are more complicated. So both domestic and foreign suppliers, they enjoy higher prices, while consumer buy less at the higher price. Domestic producers then supply more, there are fewer imports, and the government collects no revenue. Now comes the term embargo. An embargo on imports from one particular country is a total ban, is effectively a zero quota. Okay. So basically, if I'm going to say embargo on imports from one particular country is a total ban, this means that restricting the import and export of goods and services to you can say from a target country. It is totally prohibit, or they totally restrict all the imports and exports. Okay. Then hidden export subsidies and the imports restriction. So there is a range of government subsidies that are being provided and assistance for exports. So are you aware about the few subsidies that are being given to the exporters? Any of the law subsidies that are being provided? In order to promote the exports of goods. Yeah, I'll just continue with this chapter. Oh, better answer. The subsidies that are being provided. See, export, like over here for export that is being given is the export credit guarantees that the assurance against bad debt for the overseas sales. Full coverage is being given, financial help such as the government grants are being given, or general state assistance, or like export promotional capital goods scheme is there where 30% of your machinery cost is being reimbursed by the government, or there are duty drawbacks are there. The in terms of GST refund is being provided. So there are various, you can say, in the form of government assistance is being given in order to promote the exports. Then comes for imports, complex import regulations and the documentation or special safety standards demanded from the imported goods and so on. So here the documentation and all is being increased, you can say, in order to restrict the imports. Okay, there are various regulations being introduced. So the difference in, yeah, tax rebates, yeah. So in addition to economic problems, there are legal barriers to trading between the nations. For instance, international contracts. So a contract is something that is being defined by the law. And so as the law varies from country to country, maybe one thing in one country and a different thing in another, it may have different legal consequences in different parts. So of the world, and also what makes an agreement legally binding is likely vary from country to country. Now comes the conflict of laws. So difference in law, it also raises a problem. People wanting to engage in international trade, say A from country Z wants to trade with B that is from country Y. A wants to trade with A wants to trade with B, and A is in country Z and B is in country Y. If the relationship breaks down, the following issue could arise. Now, see, two persons in two countries they are in the same wants to trade with each other. For example, any of the reasons the relationship breaks down. Now, what will the issue be arising in such a scenario? Let's see. First is A could claim that under Z's law, no contract was ever formed. Now, A could claim because since Z is in the country Y, so A could claim that under Z's law, like under the country where A is there, no contract was ever formed. Now, this is A's contention, okay? Now, what B would claim, B could claim that under Y's law, no contract was ever formed. He could also say this thing under country Y, no contract was formed. or both parties could claim that the contract is not legally enforceable in their country. This could be the scenario, right? The remedies available for broken contracts in the different countries may differ. The parties might disagree on the choice of country in which to seek legal resolution. A will say, I want to seek in my country. B will say, I want to seek in my country. Then they might seek legal resolutions in their country and be unable to enforce them. So conflict of law is where parties from different nations, they have a legal dispute, and it is necessary to determine which national law governs the validity of the legal situation. So this is all about the conflict of laws. So if I'm going to ask you which of two of the following are the taxes, so what will be the answer? Just write and tell me. Right? More answers? Since most of you are saying first is the tariff and second is the custom duties, let's see. It is the correct answer. Now comes the international treaties, conventions, and the model laws. Okay. So countries have sought solution to these problems of the conflict of laws that are there. So what were the solutions that country have sought? Is by coming to agreements with each other by enacting various treaties, conventions, and the model laws. So what are the solutions to the conflict of law? By enacting agreements in the form of treaties, conventions, and the model law that regulate the international practices. So these are all examples of the public international law. Now comes the treaties. Types of international agreements are the treaties, the UN Convention, and the model laws. Let's look at it. Under treaties, these are the formal agreements between the two states or the international organizations that bind them. So they are a primary source of international law. Okay. Then comes the UN conventions, so agreements which are binding under international law on states and other entities. For instance, the Rome Convention 1980 set out policy on what law should govern the validity of international contracts and was introduced into law in the UK in 1991. It sets down a general principle that if the parties have a written contract and have expressed preference for a particular law in that written contract, that law should govern the contract. So this is known as the choice of law. So if I'm going to say like both the treaties and conventions, both that could be used interchangeably, right? Treaties and conventions. So the basic difference, if you're going to see, is that treaty can cover wide range of issues while a convention is usually forced on a specific area of issue or a specific area of law, okay? And treaty can cover a wide range of issues. First difference will be this. Second will be that treaties are typically negotiated between smaller number of countries, while you can say the convention is open to the for signature for large number of countries. Treaties for a you can say smaller number of countries, and this conventions are being open to the large number of countries. In terms of legally binding, both treaties and conventions have legal binding, but often what happens is that they have strong enforcement mechanism, the conventions, okay? Now comes the model law. So law that countries may adopt in their own national law. So these makes practice uniform on an international basis and iron out any remaining problems. So Though treaties and conventions, I would say they could be used interchangeably, but convention is more commonly used in terms of environmental protection, you can say, or in the human rights. Okay. Now comes the United Nations. So that is the international organizations in trade. So what we have done till now, by looking at the chart, we have understood the international law, the types of international law. Now comes the international organizations that are there in trade. First is the United Nations. So are you all aware about this United Nations? Yes. Let's see. What is the purpose of UN? We're going to see the purpose of various international organizations in trade. Okay. So almost every independent state in the world is a member of UN, that we all know, right? So UN was started in 1945 when the then members ratified the UN Charter. The purpose of UN are to maintain peace and security. First purpose. Second is to maintain peace and security. Second is to develop friendly relations among the nations. Third is to cooperate in solving economic, social, cultural, and humanitarian problems. And fourth is to protect the respect for human rights and the international freedoms. Fine. So member nations are required to develop and codify the international law. Currently, there are over 500 UN conventions, treaties, and standards which legally bind the states that ratify them. Currently, how many are there? Over 500. So there are two bodies in the UN that are involved in drafting international law. What are the two bodies that are involved in drafting international law? Now, this is the important part. First is the International Law Commission. Second is the UN Commission on International Trade Law. Two bodies in the UN that are involved in drafting international law is the International Law Commission. Second, UN Commission on International Trade Law. This is important. You have to remember this, okay? Now comes the UN Commission on International Trade Law. So it is the core legal body within the UN field of international trade. Can you see this? It is the core legal body. Now the question might come, which is the core legal body within the UN in the field of international trade? So you should be knowing UN Commission on International Trade Law. It was established in 1966 when the General Assembly recognized that the disparities in the national law governing international trade, they created obstacles to the flow of trade. So the UN Commission on International Trade Law, it operates as follows. Their functions being given. A number of member states are being elected by the UN General Assembly to form UN Commission on International Trade. It is structured as to be the representative of the world's various geographic regions, economic and the legal systems. The Commission carries out its works at annual sessions that are held in alternative years at UN headquarters in New York and in Vienna. Members of the Commission are elected for the term of 6 years and have the member term expire every 3 years. So now this is the important line, okay? You should be knowing this. The Commission operates through working groups composed of all member states of the Commission, non-members of the Commission, and other interested international organizations. They are invited to attend sessions of the Commission and of its working groups as observers. So now this line is also equally important. So they can participate in any discussion to the same extent as members. Now comes the use of United Commission on International Trade Law. That was the task of harmonizing and unifying the law of international trade by coordinating the work of the organization, promoting wider participation in the existing international conventions, preparing or promoting the adoption of new international conventions, model laws, and uniform laws, promoting ways and means of ensuring a uniform interpretation and application of international conventions. Now comes the collecting and disseminating, that is, distributing information on national legislation and modern legal developments. Then establishing and maintaining a close collaboration with the UN Conference on Trade and Development. So these are the few, you can say, the role which is there of the United Nations or Commission on, United Nations Commission on International Trade Law. Now comes the various achievements that are being given. So it has achieved the following outcomes among the others. So these are the, you can say, the various achievements that is being given. Now is the question, that is the activity. So the core legal body of UN is, you can say, UNIDROIT. That is true or false? Okay. Right. It is false. But it is this one. It is being given. United Commission on International Trade Law is the core legal body within the UN in the field of international trade law. Okay. Now comes the International Chamber of Commerce. It was formed in 1990 to serve world business by promoting trade and investment, open market for goods and services, and the free flow of capital. What is the role of ICC? It was originally created by the business leaders from the Belgium, UK, France, Italy, and the US. It is now a worldwide business organization with thousands of members companies and association for over 100 countries. It makes representation to government on issues related to international trade. What's the role of ICC? It makes representation to government on issues that are related to the international trade, develops codes of practice to encourage businesses to operate with minimum of government intervention, cooperates with and advises the UN and provides several services, practical services to business and combat commercial crimes, set up the International Court of Arbitration in 1923. Now, this is important. Who has set up the International Court of Arbitration in 1923? That is International Chamber of Commerce, right? So the International Chamber of Commerce established the International Court of Arbitration. Now, true or false? Question. True, right? So only the various bodies that are being given. So you have to know what the function they are performing. And if specifically anything important is there, that I'm making you mark, okay? So you have to remember that. Rest of the part is for your knowledge purpose. Now comes the World Trade Organization. It devotes itself entirely to the international trade in goods, services, traded inventions, creations, and intellectual properties. It promotes the free flow of trade by removing the obstacles, whatever the obstacles that are there in trade. It tries to remove that and to make sure that individuals, companies, and government know what the rules are. They are well aware of all the rules. Now, what is the roles of WTO? It includes the administering and discussing the trade agreements. Now, this is important, okay? What is the role of WTO, World Trade Organization? First is administering and discussing the trade agreements, settling trade disputes, reviewing national trade policy, and assisting the developing countries. Now, these are the roles of the World Trade Organization. Now, WTO agreements, that is, it contains the principles of the liberalization of the free trade, They include commitments by each country to lower custom tariffs and other trade barriers and to open and keep open services markets. So they also set procedures for settling the disputes. Now, if you're going to look at the structure of the World Trade Organization, just let's have a look at it. First is the Secretariat that supplies technical support and assistance for various council and the committees, ministerial conferences, and the developing countries. Then the ministerial conference is the WTO's decision-making body. So decision of the WTO are being made by the entire membership, usually on the basis of the consensus. Now the General Council, which meets several times a year as a trade policy review body. Then dispute settlement body, it operates a dispute settlement procedure for resolving trade quarrels. Then the special council such as the Goods Council, Service Council, and the Intellectual Property Council that report to the General Council. And the committees, working groups, and the working party that deal with the individual agreements. So now comes the Organization for the Economic Cooperation and Development. Till now, how many have we done? Let's look at the chart. We have done United Nations, we have done UN Commission on International Trade Law, we have done International Chamber of Commerce, World Trade Organization. Now we are left with Organization for Cooperation and Development and International Institute for the Unification of Private Law. So, the Organization for Economic Cooperation and Development is a group of member countries. Okay. Now comes the role of Organization of Economic and Cooperation Development. What is their role? It was basically developed in 1961. Give me a second. It was developed in 1961 out of an organization that is being set up to administer the American and Canadian aid to Europe after the Second World War. In order to administer the aid to Europe and after the Second World War, it was being developed. Originally comprised countries in the North American and Europe, but has expanded to include countries such as Japan, Australia, Mexico, and Korea. Has members from most of the continents. Its purpose is to be a forum to discuss, develop, and refine economic and social policies. Now, what is the purpose of OECD? Now, this is the important line, okay? To discuss, develop, refine economic and social policies. It has created both legally binding agreements and also non-binding agreements that are such. Non-binding agreement means these are such only guidelines for multinational enterprises that are not legally binding. It also invites the non-member countries to subscribe to its agreement as well as members and is involved in a further 70 countries, including China, Russia, Brazil, and some countries in Africa. Okay. So this was all about Organization for Economic Cooperation and Development. Now let's come at the last one, that is International Institute for the Unification of the Private Law. So International Institute for the Unification of the Private Law is an independent intergovernmental organization which studies the need for and how to modernize, harmonize, and coordinate private international law and in particular trade law. So structure of UNIDROIT is structured as follows. First is the Secretariat, who is responsible for the day-to-day running of UNIDROIT's work program. What is the role of Secretariat? To responsible for the day-to-day running of the UNIDROIT's work program. That was the role of the Secretariat. Now comes the Governing Council. It supervises Unidroid's policy. It draws up the work program and supervises how the Secretariat is carrying it out. It supervises the Unidroid's policy and draws up the work program, whatever the work program is there. And it also supervises how the Secretariat is carrying out his work. How is he is doing his work? So he supervises that also. Who? The Governing Council. Now comes the General Assembly, that is ultimate decision-making organ of the Unidroid. General Assembly is the ultimate decision-making organ. Okay? Now please have a look at it once. This is very important. For day-to-day running of Unidroid's fund program, who is responsible? Secretariat. Who for supervising Unidroid policy and supervising the work of the Secretariat, who is doing? The Governing Council. And who is the ultimate decision-making organ of Unidroid is the General Assembly. Now, if we're going to solve the question, if this comes on it, so you're knowing the answer, right? Now, what is the work of Unidroid? Its basic objective is to prepare modern, harmonized, and uniform rules of private international law. It relates to the private international law. Its rules have traditionally tended to take the form of international conventions, which apply automatically in preference towards states' national law, and once they have been implemented. However, it has recently favored alternatives such as the model laws, general principles, and the legal guides. Okay. So, two bodies of the UN which are involved in drafting international law. What is the answer? Okay. Okay. So most of you are saying first and second. So let's see. It is the correct answer. So these two bodies are involved in drafting the international law. So here is the summary of the chapter. Please look at it. It was a very small chapter. It is the smallest chapter of this syllabus. We have done the types of international law, the international trade, the various terms which we have done, the international organizations in trade, that is the UN Commission on International Trade Law, International Chamber of Commerce, World Trade Organization, Organization for Economic Cooperation and Development, International Institute of the Unification of Private Law and Drawing. So please have a look. Just 2 minutes I'm giving it to you. Then I'll jump to the question and answer. Okay, now I'll share the question answer with you on this chapter. So far, are you all having any doubt from this chapter? You can ask me if any doubt is there. It's all theoretical, this chapter is. Okay. So ready for the question answer round? All of you? Let's start. I need response. Okay. So, which of the following types of law consist of rules and principles that apply in general to the relationship of a sovereign states and the international organizations? First is the private international law, public international law, or common international law. What will be your answer? Relationship of sovereign states and the international organization. More answers? Okay, since the majority of the option that I have received is public international law. Let's see. That is the correct. Public international law, it applies to the conduct and relationship of the sovereign states and the international organization. Private international law, it regulates the cases involving the national law between two or more states. Okay. Now comes UN model laws are an example of which of the following type of law? UN model laws. International criminal law, public international law, private international law. Right, right, right. Okay. Since most of you say private international law, so let's see. It is the correct answer. Private international law, it regulates the cases involving the national laws between two or more states. That is, UN model laws are an example of this. Public international law applies to the conduct and relationship of the sovereign states and the international organization. Fine. Now comes which of the following basically describes the conflict of laws, right? The conflict of laws we have studied. Two example was also there, A and B from country Y and Z. Then remedy was also being provided, right? So which of the following basically describe this word conflict of law? First is the disagreement between the nations concerning differences in the human rights legislations. Disagreement between business organization in different nations caused by different national laws, and disagreement between nations concerning protectionist trade policies. Try. The one who have answered, they have given the right answer. Okay, since most of you say the option B. So let's see. It is correct. The disagreement between conflict of laws are dispute between the parties in different nations, not between the national governments. So disputes are caused by each country having different laws on a particular issue. Which of the following type of international law is not automatically binding on nations? Which is not automatically binding on nations? This we have done it. First is the UN Convention, second is the international treaties, third is the UN model laws, which is not automatically binding. You have to go with the word. In MCQs, you have to be very particular with the question. What the question requires, you have to focus on that. Okay? Not automatically binding. And not is even highlighted. Treaties and conventions could have been used interchangeably, but they were, one line was there. Try, you will be able to do it. Just think what I told you. No guesses? I've only got one answer for this. That is strange. At least try. That is more important. You're trying. Yeah, now you are correct. Okay, good. You are trying. That is important. You should try. That is more important. Correct, right and wrong is a different thing. Later on, that will also improve. You will get all the right answers. Just initiate with the trying that you're trying to answer. Okay? Correct. You've given the right answer. So let's go with the majority of the one. The option is UN model law, since most of you have given this answer. So, and the correct is the UN model laws. It may be adopted by nations into their own national law, but this is optional. Conventions and treaties are binding on nations, right? These are agreements, then sign up to them. Which of the following is the principle that determines which law apply to an international contract dispute? First is the conflict of law, choice of law, or cooperation of law. Okay. So I've got the answer B. So let's see. That is choice of laws. So the Rome Convention 1980 sets out the principles of choice of laws. So this is where parties to a written contract have expressed a preference of a particular law that will apply to the contract. Then that law should govern the contract. Okay. Now comes, which of the following describe the principle of choice of laws? First is, the principle of choice of law states that unicitral shall determine which country's law will apply in particular situation. The principle of choice of law states that where parties to a written contract have expressed a preference for a particular law to supply, then that law should govern the contract. Then principle of choice of law states that where parties to an international contract are in dispute, then the relevant UN model law shall determine which particular law applies. Now, what will be the answer for this? It is a long definition, but just give me ABC. Right? I'm getting the right answer. It's nice. So, okay. Any more try? Okay. Since the majority is for B, so let's see. It is the right answer. So the principle of choice of law states that where parties to a written contract have expressed a preference for a particular law to apply, then that law should govern the contract. So the principle of choice of law states that where parties to a written contract have expressed a preference for a particular law that will apply to the contract, then that law should govern the contract. Okay, since most of you have given the right answer. Then comes, which of the following organization is a major source of international trade law? More answer? You can answer this. It's very simple. Okay, since I have got majority for option C, so let's see. It is the correct answer since UNCITRAL is the core legal body of the UN. It is responsible for a number of model laws such as the UNCITRAL. Model laws on international commercial arbitration, ICC is the International Chamber of Commerce and the WTA is the World Trade Organization. Both organizations, they operate in the field of international trade but do not create model laws. Now comes the eighth question that says that agreement that are being formed by which of the following international organizations are based on the liberalization of free trade. That is WTO, ICA, UNCITRAL, UNITROL. Liberalization of free trade, as the name suggests. Now, you have got the hint. Right? But I need more answers. The one which all who have given are given the right answers, but I need more answers. Okay. That is the option A. I'll proceed since I've got that. It is the correct answer. World Trade Organization seeks to promote the free flow of international trade, and its agreement are basically based on the principles of free trade. So the other organizations are international bodies concerned with the trade, but do not have the free flow of trade as a goal. Now comes, which of the following international organizations set up the International Court of Arbitration? Since I have highlighted this point, if you can recall. Now tell me the answer. Which options? Right. I'm getting the right answer. Great. All of you have given the right answer. So I'll go with the option ICC. So International Chamber of Commerce set up the International Court of Arbitration in 1923. The UN, WTA, and Organization for Economic Cooperation and Development are all international organizations, but they did not set up by the ICA. Now comes barrier to free international trade are often a source of dispute between the nations. So which type of barrier to free trade involve a total ban on imports from a particular country? This term I made you highlight. Just think. Yeah, correct. I've got the right answer. The first answer right now. All the answers are correct. It's embargo. Right? It is a total ban on imports from a particular country. A tariff is a tax on imported goods. So an import quota is a restriction on the quantity of a product that may be imported but stops short of a total ban. Import restrictions are rules and regulations that make imported goods more difficult. Then comes which type of barrier to free trade involves taxing imported goods. Taxing imported goods. Now look at the option custom duties, import restriction, import quotas, or embargo. Right. All of you are giving the right answers. That's great. First is custom duties. So a custom duty is like a tariff, is a tax on imported goods. An embargo is a total ban on imports from a particular country. An import quota is a restriction on the quantity of a product that may be imported but stopped short after a total bans. Then import restrictions are rules and regulations that make importing goods more difficult. So these are the differences that are being given over here. Now comes which of the following sources of international law may be adopted by nations into their own national law and are a particular source of rules to help business organization avoid the problem of conflict of laws? Right, right. Correct. Absolutely correct. Okay. Since most of the people say that it is UN model laws, let's see. Correct answer. UN model laws, such as the model law and international commercial arbitration, so may be adopted by nations to help businesses avoid the problem of the conflict of laws. So the other options are automatically binding on nations that sign up to them. Now comes the dispute settlement body. They operates a procedure for resolving trading disputes between the member countries. So which of the following international organization is the dispute settlement body? Is it WTO, OECD, UNITROID, or UNICITRAL? So here the conflict of answers are there. Everyone is giving me a different answer. Trading dispute between member countries. Just look at the words. Trading dispute between member countries. Here the trading dispute is there. Now think. It relates to the which option? Okay. Now I'll go with the first option. Let's see. That is World Trade Organization. So the dispute settlement body is part of the World Trade Organization. So what I'm trying to say, just look at the question first. What is the question says? Since trading dispute is there, then itself you have to have that notion that like if something related to trading is there, so it might, if you're not sure about the answer, if you know the answer, then it's very good. You're not giving a second thought. When you don't know the answer, just find the clue between the question and answer, what clue you can get. Okay, so just focus on that. Okay. Which of the following international organization has its purpose as being a forum to discuss, develop, and refine economic and social policy? Now, again, the question and the answer is related. Now you need to find the clue. Right. See, all of you have given the right answer. That's OECD. The purpose of Organization for Economic Cooperation and Development is to be a forum to discuss, develop, and refine economic and social policies. Now, which of the following international bodies is an intergovernmental organization whose rules are in the form of international conventions that apply in preference to a state's national law once they have been implemented? Now give me the answer. Intergovernmental organizations whose rules are in the form of international conventions that apply in preference to the state's national law once they have been implemented. Right. I'll go with the second option now. That is International Institute for the Unification of the Private Law is an intergovernmental organization whose rules are in the form of international conventions. Clear? So now we are done with the second chapter as well, along with the solving of the question answers also. So now have you all got an idea like how the questions are going to come and how you're going to revise the chapter? Yes? Any questions so far from any of you? You can ask me. Okay, no questions? I will be available on WhatsApp. If any one of you have any doubts, you can contact me anytime. You can drop me a message. I'll respond it to you as soon as I'm be able to see. And hopefully you have enjoyed the class. You're not in my WhatsApp group. Okay. So whoever is not there, please contact with the team, PG team. They will add you in the group, okay? Whoever is not there, please contact. From there, you will be getting all the notes and all. So it is important for all of you to be there in the group. It is easier for me to connect if anything is there, okay? Fine, then see you next week. And please try to manage to get the book and revise both the chapters simultaneously since it's an on-demand exam. Try to give as soon as I complete the syllabus, you can give your exam also. So just revise whatever I'm teaching simultaneously. You have to revise all the chapters, okay? Okay, thank you.